Hey guys, sorry about that. I'm taking a quick break from work to do this, so I just had to finish up a couple things. Yeah, okay, so just right off the bat here, I'll tell you, don't watch this stream live if you don't want to drink before noon, okay? that's probably not a good idea. Um, Give me 1 second to get this here. So the judge actually just ruled on this, and we're gonna go through Vanzan's response, but I'll tell you right away, won't wait till the end, that the judge denied, of course, Wayfarer's motion to compel. Um, it's like a one of those blue stamp orders. So he didn't write a whole document or anything. So it just says the motion to compel is denied for failure to satisfy Rule 4.c of the court's individual practices in civil cases. Vanzan may move by letter for recovery of its expenses, including reasonable attorney's fees, which I fucking hate these people. I'm sorry. I'm so tired of this. But yeah, we'll go ahead and read through what Vanzan had said in response. I did a video this morning going over the motion in the first place. So if you haven't seen that, you can go back and watch it after. Let me pull this up real quick. The actual the letter that they wrote is very Blake Lively-esque. So I could get a sip of water. Give me 1 sec. Okay. So, Joe A. Bad says, I was unsubscribed to Lauren's channel. What? So that happens. I don't know. It does it to me too. Like, I got unsubscribed from Dave's channel a couple times. I never did it on purpose, you know? So, I don't know. You just got to check, I guess. But yeah, YouTube has problems with that. I'm not sure what's up with it. Okay. So, if anybody, on the off chance you don't know what Vanzan is a piece of shit pretending to be a company. But we're not going to get too far into that right now because I don't have a whole lot of time. So, all right. We write on behalf of non-party Vanzan in response to the letter motion to compel filed by defendants, which purports to compel a corporate representative for Vanzan to testify as to specific time period in its upcoming deposition, as to a certain deposition topic. Okay. This is a curious request, given that Vanzan confirmed on multiple occasions that it was producing a corporate designee on September 30th to testify to all topics in the deposition subpoena. So they didn't actually say like who the designee is, and they've been asked repeatedly to say like who is the witness who will be testifying to which topics, and they still won't say. And then in the list of people who will be attending the deposition that Wayfair was also asking for, they only listed attorneys. The only people listed, and you'll see that in the emails, are attorneys for the company. The company which has fewer employees than it does lawyers. Because it's a fucking broom closet. It's not a real company. All right. This letter motion is either an effort by defendants to use the court's docket to advance an unfounded narrative and generate media coverage around Vanzan, a frequent boogeyman of defendants, or an attempt to manufacture a dispute where none exists. So the thing about being the boogeyman of the defendants, there is absolutely no reason to believe that what Vanzan did was in good faith. So that's ridiculous. Okay. Regardless, defendant's motion does nothing more than waste the time of the court, the parties, and third-party Vanzan. Well, it's not like Vanzan does any business, so they should have plenty of time to waste. Unless ordered otherwise, Vanzan plans to produce its corporate designee to be questioned on the subpoena topics on September 30th. Who? Who is your designee? And told defendants that in writing on multiple occasions before they filed this baseless motion. Accordingly, there is nothing for this court to compel, and the motion should be denied as moot. Okay. With respect to the narrow issue defendant's motion raises, which is Vanzan's objections regarding the relevant date range of certain topics, they never once raised or conferred with Vanzan on this issue. Nor has Vanzan ever refused to provide testimony on any of the topics set forth in the subpoena. So that's the issue with the date range that they're being a little squirrely about here. They don't want to testify to anything that happened in the lead up to the Vanzan lawsuit. They said the date of filing, fine, and after that, but what happened before that is part of the whole thing. So like the issue was that Stephanie Jones apparently, allegedly, improperly, like gave the data from Jen Abel's phone to Blake Lively and her publicist, Leslie Sloan. Then the Vanzan lawsuit was filed in order to kind of like backtrack and make it look like they actually received that information from Stephanie Jones through a legal subpoena. So that's the problem. I'm going to get some water real quick. One sec. All right. Okay. Upon receiving their motion, we ask counsel for defendants to withdraw their motion to compel because there is no dispute and therefore nothing to compel. They refused and instead demanded that all objections be waived, including privilege. That's actually not true, which we'll see in a minute, because there's another email that's been provided by Kevin where he shows that he did not demand they waive privilege. That's stupid. There is no issue for the court to resolve and no need for defendants to waste the court's resources with this motion. Okay. A review of the relevant events reveals that defendant's motion is without basis. Okay. On September 11th, counsel for Vanzan accepted service of the subpoena, and that's talking about the deposition topics. At no point did defendants ask for a meet and confer in advance of serving the subpoena or following service of the subpoena. On September 18th, counsel for Vanzan asked to meet and confer with defendants. At the meet and confer, counsel for Vanzan informed defendants that it would produce a designee to testify on the topics and would serve general objections on September 24th. Okay, then they served their objections and responses on the 24th. At the end of the objections to each of the specific topics, Vanzan affirmed that it would produce a deponent to testify as to the topics and listed no specific limitation other than privilege. This is in stark contrast to simultaneous objections filed to defendant's document subpoena, where only objections were listed. Vanzan also offered to meet and confer. On September 25th, counsel for defendants, so that was Kevin, sent an email to counsel for Vanzan offering to narrow two topics and asking for the name of the individuals who would attend the deposition in person. Counsel for defendants also demanded that Vanzan respond by noon Eastern on Thursday, September 25th, if Vanzan withdraws its objections to the topics. If the objections are not withdrawn by such date and time, we will seek appropriate relief from the court. Okay. On September 25th at 10:28, counsel for Vanzan responded that we need to discuss with our client and expect to get back to you later today or tomorrow morning with respect to the specific issues you raise. In the meantime, confirming we are planning on having a deponent testify on Tuesday. Okay. There were no additional emails from defendant's counsel, no phone calls. Defendant's counsel never raised any time period issue, nor did defendant's counsel give counsel for Vanzan the courtesy of consulting with her client. Okay. As counsel stated she was doing. Defendant's counsel made no effort to apprise counsel for Vanzan of any specific issue related to the objections. That is in stark contrast to the other specific components of defendant's 12:38 a.m. email, which offered, for example, narrowing of certain topics and a discussion about relevance. As such, it is difficult to see this motion to compel as anything other than an attempt to manufacture a dispute and drag non-party Vanzan into litigation for show. Shut the fuck up. I'm so tired of that. Allowing defendants to reiterate their misleading narrative about Vanzan for the press. If defendants had any genuine concerns about the time period objection, they would have raised it with Vanzan before inconveniencing the court. That is the purpose of the meet and confer requirements and consistent with principles of professional decorum and professional efficiency. Okay, one sec, guys. Okay. Yet at 8:56 p.m. Eastern Time on September 25th, defendants filed a motion to compel Vanzan, which seeks to compel Vanzan to testify to the original time period in the subpoena. Okay. The footnote here, too, says defendants characterize this as a request to compel testimony about the full period of Vanzan's relationship with plaintiff Stephanie Jones and Jonesworks. Defendants use their motion as a vehicle to reiterate their baseless claims regarding how evidence of their misconduct was obtained from Miss Abel's phone and their media-friendly theory about the underlying Doe litigation in New York court. Okay, so if that is so baseless, Jesus Christ, if that is so baseless, and this is just a media-friendly theory, like why can't you answer it to anything? Why can't you answer to why you had any sort of lawsuit against John Doe's 1 through 10 and immediately went for the Wayfarer parties? And how could you say that the Wayfarer parties violated a contract with you when they had nothing to do with you ever in the first place? It's ridiculous. Okay. Vanzan is preparing a deponent to testify about any alleged relationship Vanzan had with Miss Jones and Jonesworks as set forth in the relevant topics. Okay. Roughly simultaneous to their filing at 9:02 p.m. Eastern, counsel for Vanzan sent an email accepting the proposed narrowing of topics 4 to 5, providing the names of the designee and the attendees for the deposition. Okay, so the name of the designee, there's no way they actually provided that because they actually put the list of people who are attending in the emails. They did not name a designee. The only people they listed are attorneys. And confirming again that Vanzan would attend deposition. After reviewing defendant's motion, counsel sent defendants emails requesting they withdraw the motion and explaining why. Counsel for defendants responded and refused. Okay. The motion is an effort to manufacture a dispute so defendants can further burden non-party Vanzan and provide more fodder for an ongoing media campaign. God, I'm so tired of hearing that. As defendants know, had Vanzan sought to limit the scope of the topics, it had to file a motion for a protective order with his court. Okay. Instead, Vanzan served objections and responses, met and conferred as appropriate, and confirmed multiple times that its designee would testify on the topics. Okay. In footnote 3 here, it says defendants may note that their 12:38 a.m. email. Okay. They keep mentioning the 12:38 a.m. email. Kevin. Don't email these legal skanks late at night. Okay, you don't want to do that. You don't want to do that. But all right. The 12:38 a.m. email had a vague catch-all request that Vanzan withdraw their objections to the topics. Given the sprawling nature of the defendant's subpoena, Vanzan asserted several standard objections, including as to relevance, privilege, work product, burden, time period, and overbreadth. It appears that the real reason defendants made a catch-all demand was to create the appearance of a dispute and a meet and confer so they could file a motion to compel on any of the objections. Defendants had multiple opportunities to raise any concerns about the time period objection specifically, but never did, and simply demanding that all objections, including privilege objections, be withdrawn is not reasonable or made in good faith. So this issue about them having time to raise concerns about the time period, Kevin's going to mention that in one of the emails we'll see. In conclusion, the court should deny defendant's motion as moot. There is no dispute between Vanzan and defendants. That's awesome. Sorry, that's so stupid. As Vanzan has stated to defendants and consistent with federal practice, Vanzan will produce a designee to testify as to non-privileged information regarding the topics without waiving any objections. Okay. And then we're going to go over to these emails. I want to start down here. Hang on. Hold on. I think we have to go towards the bottom. Okay. Yeah, so I'm going to skim over some of this that we've kind of seen already because Kevin included some emails in his declaration. Okay. Willing to narrow topic 4, blah, blah, blah. That was the 1238 email. Okay. Okay, and then they're saying here, the following individuals will participate in person. Maggie O'Donnell, Naomi Bates, and Justine Harris. John Federal, one of the other attorneys, I don't know if I'm even saying that correctly, will participate via video conference. So these are all attorneys. Those are all attorneys. Okay. We don't need to read that. We already know that. Okay. Kevin, we've just reviewed your motion to compel, which we were quite surprised to receive. As you can see from the below, we accepted your narrowed topics for topics 4 and 5 and confirmed that Vanzan will produce a corporate designee on Tuesday. As we had told you in response to your email from earlier today, we also told you during our video meet and confer on September 24th, we were producing a corporate designee. Who? Who is your designee? God damn it. Like, just... Jesus. While I've only had a chance to undertake a cursory review of your motion considering the hour, he did send it late at night, it appears that you are raising an issue as to a time period objection that we listed amongst a host of other objections and papers that were timely served yesterday. In your email this morning, you did not raise any issue regarding this objection, so we've had no meet and confer discussion on this topic. If you had a concern about what our objections and responses said about the time period, you have an obligation to raise those with us. Your motion to compel is the first time we are hearing anything about this issue. Regardless, as you know, under the federal and local rules, had we wished to impose a limitation on what the corporate designee would testify to, we would have needed to move for protective order, which we did not do. At this point, you filed a motion to compel a Vanzan corporate designee to testify on a topic for which we already told they would appear and testify about. Maggie's email below, as well as her email from this morning, made it crystal clear that we were producing a Vanzan corporate designee, so unnamed random designee. And she told you earlier today that we would respond to your email either today or tomorrow morning regarding your suggestion regarding narrowing topics 4 and 5. As such, there is no dispute between the parties. So the dispute is over the time frame. And then also, they still won't name the witness who's being deposed. I don't know the rules on that. I mean, I think it's kind of ridiculous that they wouldn't name the witness that's being deposed, but whether it's legal or not to just withhold that, I think that it's just shady as fuck, which is consistent with everything else this company has ever done. So, all right. As such, please withdraw your motion by 11 p.m. Eastern. If not, we will file a response, which makes your course of conduct clear and sets forth your bad faith conduct in not only raising an issue that was never raised with Vanzan, but also raising a dispute when you knew no dispute existed. If your motion is not withdrawn within the hour, and we need to file a response, we will seek cost, fees, and any other sanctions for such conduct. Of course you will. These people are kindergartners telling the teacher about everything. All right. John, in my email from earlier this morning, essentially last night, I demanded that Vanzan withdraw its objections to the topics. This is Kevin writing. I also told you that if the objections were not withdrawn by noon Eastern, we would seek relief from the court. You failed to withdraw the objections, which never should have been lodged in the first place, especially given the court's prior ruling that Vanzan's communications with Jonesworks are relevant. You attempted to bury within a host of other objections the fact that Vanzan's designee would not testify to anything predating the Vanzan lawsuit. If you are now ready to withdraw the objections, please prepare for my review of formal stipulation to that effect, and we can submit to the court to be so ordered. Oh my God, Lay, I am not. Oh, it's a guy. I'm not reading. I don't want to read all that, man. I will. I will, but I don't want to read all that. Let me get some water real quick. Okay. Kevin, it seems clear to us that your email from last night was an effort to set up a motion to compel without giving Vanzan any notice of the nature of any disagreement. We find this very disappointing. You know what else is disappointing? The fact that you used a broom closet for a company to subpoena Stephanie Jones to get communications without the Wayfarer parties having a fair attempt to object to the subpoena because they have nothing to do with Vanzan in the first place, and that was actually Blake Lively. So I really want to hear about Vanzan and, fairness or notice or anything like that. I think that's hugely hypocritical and stupid. I understand that they're making a point here and that they're just doing their jobs, but still, I'm so fed up with it. I'm just kind of like, shut your mouth. Shut up. Okay. We find this very disappointing and completely inconsistent with the spirit of meet and confer and the need to be efficient with the court's resources. The chronology and communication speak clearly for themselves. Okay, we've seen that. If Vanzan wanted to refuse to produce a designee based on relevance, we would have had to move for protective order, blah, blah, blah. We've seen that. Okay, they're just talking about how they discussed the topics. Okay. For example, when we asserted objections based on privilege, work product, relevance, duplicity, burden, and yet we repeatedly told you we would produce a designee for all topics. And when we listed such objections to your specific deposition topics, we said at the end of that regardless of objections, we would produce a designee to testify that the topic and noted no limitation. This stands in stark contrast to our response to your document requests, where we listed objections and never once stated that documents would be produced. We want to be very clear, since your motion and email seem entirely focused on the time period, you never raised any concerns about the time period objection with us. Your 12:38 a.m. email purposefully buried the issue in a vague demand that Vanzan withdrew all its objections, including privilege. At the same time, your email outlined multiple specific issues. We spent the day focused on the specific issues you raised so we could get back to you when we said we would try and reach agreement on those issues. We acted in good faith in trying to address your 12:38 a.m. email, and our Jesus, okay, we get it. He sent the email late, and our subsequent email response shows that. You had multiple opportunities to ask us about the time period. You did not do so. The first we heard about the time period issue was in your motion to compel, which we were shocked to see. I mean, you couldn't have been that shocked to see when he said, withdraw by noon, or we're doing this. Whether or not you think it was a reasonable motion to compel, they shouldn't have been shocked by it, because he literally said, respond by this time or this is what I'm doing. And then they didn't really give the answer by that time. So, they responded, but they didn't, do what was requested. Okay. If you had raised the issue, we would have gotten back to you with a response reiterating our same position, and you would not have had to file your motion. Okay. In any case, there is no dispute. As Vanzan has said repeatedly, we are producing a designee to testify about the topics, consistent with the topics as they are narrowed by our mutual agreement. We will assert the necessary objections at the deposition to questions, as is our right, but the only limitation instruction we plan to provide our designee is that of privilege, or if the questioning goes beyond the topics you listed. Okay. We reiterate your request that you... I think they mean our request. Whoa, I can't talk. We reiterate... It's a good thing I'm not on the face cam right now. We reiterate our request that you withdraw your motion. There is no dispute, and it's a waste of court's time. You have until 8 a.m. to do so. If you do not, we will file a response, point out your bad faith conduct to the court, and request fees, costs, and other appropriate sanctions for having to respond to your improper motion. Thanks, John. Okay. This is from Kevin this morning. John, Vanzan's written objections state that Vanzan will only provide information for each of the topics starting from, on, or about the filing date of the Vanzan lawsuit, which is September 27th. Please let me know the good faith basis for that objection. Upon receiving your written objections, we ask that you withdraw them by September 25th at noon. You failed to do so. We also asked you to meet and confer that same morning. You failed to do so. If Vanzan is now finally willing to withdraw its objections, please prepare a stipulation to that effect, which can be so ordered, thereby resolving the motion. Okay. And then again, they respond and say nothing. We're providing a designee. Who is your fucking designee? All right. Your request to withdraw all objections, including privilege, which you have no right to even request, is not something any parties have done in this litigation, and you know full well is made in bad faith. We will file our response with the courts, and we'll make our designee available Tuesday. If you no longer wish to take this deposition, Okay, man. Please let us know today by noon so we don't waste further time and effort on this matter. We accordingly reserve all rights to seek sanctions based on defendant's conduct here. All right. And then the Wayfarer parties responded. Again, give me one sec. Okay. In response to each of the 11 deposition topics enumerated in the subpoena, Vanzan objected on various grounds, including Vanzan will provide information for this topic starting from on or about the filing date of the Doe lawsuit. Okay. Vanzan's response to each of the 11 topics concluded with, subject to and without waiver of the foregoing objections and reserving the right to assert additional objections, Vanzan will designate a witness reasonably prepared to testify about non-privileged information responsive to this topic. In other words, Vanzan confirmed that it would only provide information for each of the topics starting from September 27th and not before such date. Therefore, the following statement in opposition is inaccurate. Nor has Vanzan ever refused to provide testimony on any of the topics set forth. Okay, so they're saying that's not true. The Wayfarer parties were not obligated to wait and hope that at the deposition on September 30th, which is the last day of fact discovery except for certain matters, Vanzan would withdraw the objection. Upon receiving the formal objections, we asked Vanzan's counsel to withdraw them. Of course, not a privilege-based objection. Vanzan failed to do so. In the early morning of September 25, we asked Vanzan's counsel to meet and confer during the morning business hours. Counsel stated that it needed to discuss the issue with its client, presumably Blake Lively or Ryan Reynolds, and would get back to us later that day or the following morning. As of the evening of September 25th, no response was received. Given the looming September 30th deposition, it would have been improper to further delay judicial intervention. Even after the motion was filed, and Vanzan seemingly stated it would withdraw its stated refusal to provide information predating its New York State court lawsuit, we asked Vanzan's counsel to prepare a formal stipulation to that effect, which could be so ordered by the court, thereby resolving the motion. Vanzan refused. We also asked Vanzan's counsel for its good faith basis, if one existed, for its refusal to provide information predating the Vanzan lawsuit. No substantive response was received. Notably, Vanzan still has not advised the Wayfarer parties which of the listed attendees for the deposition, whom all appear to be attorneys, is the corporate designee and for which topic. To the extent Vanzan is now agreeing to withdraw the time period-based objection, the motion should be granted as unopposed. To the extent Vanzan is maintaining such objection, the motion should be granted for the reasons set forth in our initial papers. And of course, the judge denied it, but they're saying to the extent Vanzan is now agreeing to withdraw the time period-based objection. Did they? I don't know, I feel like I read a lot of word vomit in that last one, so I'm not positive, but okay. And then they attached this email, which is kind of hard to read. Let me see if I can zoom in some more. Somebody says apparently Rule 4C means Judge Lyman feels Jen Abel failed to properly confer with Vanzan before filing their motion to compel. So probably that they, should have conferred about the time period objection. So give me 1 second. All right. And then this is from this morning, well, like a few hours ago, yeah. I don't know if we need to read that one. Okay. Yeah, okay. So this one from John, the attorney for Vanzan, says, Kevin, we've told you on multiple occasions we are providing a Vanzan corporate designee. Dude, who is the designee? It's not that hard. To testify about the topics in defendant's deposition notice and impose no limitation with the exception of privilege. Your request to withdraw all objections, including privilege, which you have no right to request, is not something any parties have done in this litigation, and you know full well is made in bad faith. So I think we did see that one. Okay. And then Kevin responds, please let me know today which witness will be testifying about which topics. I can't believe they have to continuously ask that. You are free to make whatever privilege-based objections you deem appropriate. We reserve all rights in that regard. I am reiterating my request for you to set forth your good faith basis for Vanzan's objection that no information predating its 927 lawsuit will be provided. All right. And then everything else is like what we've already seen. So. Yeah, so that was exhausting. Sorry. Attorney's fees, what a joke. Yeah, I'm like not happy about that, but it is what it is. It just gets hard to watch them kind of like take a beating, to be honest, in a lot of this stuff. But yeah. Okay. I got to get back to work, guys. But thanks for watching this with me. Don't forget to hit the like for me, and I'll be back, I'm sure, later on. If not tonight, then this weekend. Wait, actually, you know what? Let me redirect you to someone. Who can we redirect to? Oh, Ashley's on. Yeah. Okay, I'm sending you over to Ashley, my friend Ashley. Let her know that I sent you, and I'll see you guys later. Thanks.